On January 29, 2025, the U.S. Copyright Office released Part 2 of its report on copyright law and artificial intelligence AI, addressing the eligibility of AI-generated content for copyright protection when there is human involvement. This report is a significant development in the ongoing discussions surrounding the intersection of technology and intellectual property, especially as AI becomes increasingly integrated into creative processes. Background and context. The exploration of copyright in AI began in early 2023 when the Copyright Office initiated a broad initiative to examine how existing copyright laws apply to AI-generated works. This initiative included public listening sessions, extensive consultations with experts and stakeholders, and a public inquiry that garnered over 10,000 comments from creators, legal experts, and the tech community. The insights from this feedback were instrumental in shaping the conclusions drawn in the report. Part 1 of the report, published on July 31, 2024. Recommended federal legislation to address issues related to unauthorized digital replicas. Part 2, released in January 2025, focuses specifically on the copyrightability of outputs created using generative AI. Key findings of the report. 1. Human involvement is crucial. The report's central finding is that for AI-generated content to qualify for copyright protection, there must be significant human involvement in the creative process. This could involve integrating human-authored material into the AI output, making creative modifications, or ensuring that the human contribution is expressive. Simply providing prompts to an AI does not meet the threshold for copyright eligibility. 2. AI as a creative tool. The report emphasizes that AI is a tool that can enhance the creative process, aiding in editing, drafting, and generating preliminary ideas. However, ultimate authorship must reside with a human creator. This perspective reflects a historical precedent in copyright law which has adapted to new technologies over time, such as photography and digital media. 3. No need for legislative changes. After considering public input and the current technological landscape, the Copyright Office concluded that existing copyright laws are sufficient to address the challenges posed by AI-generated content. There is no immediate necessity for legislative changes in this area, despite calls from some sectors for enhanced protections for AI-generated works. For future considerations, the report indicates that a third part will be forthcoming, focusing on the legal implications of training AI models on copyrighted materials, including licensing and liability. This suggests ongoing regulatory considerations as AI technology continues to evolve. Scenarios for copyright protection. The report outlines 3 key scenarios under which AI-generated material can qualify for copyright. Incorporation of human-authored content, when a human author's work is perceptibly included in the AI output. It can be eligible for copyright. Creative modifications, if a human significantly modifies or arranges the AI-generated content, this can also lead to copyright eligibility. Expressive human contribution. A human contribution must be sufficiently expressive and creative to meet copyright standards. The report clarifies that using AI in the creative process does not disqualify a work from copyright protection. For instance, if an AI tool aids in refining text, images, or music created by humans, those human elements remain copyrightable. However, simply generating content with an AI tool without significant human involvement does not confer copyright. Public reaction and implications. The release of the report has been met with a mix of relief and optimism among creators and AI enthusiasts. Prominent figures in the AI community have celebrated the ruling as a significant victory for intellectual property rights in the context of AI. For example, artist Chris Kashtanova, who previously faced challenges in securing copyright for her AI-generated graphic novel, expressed happiness over the new clarity regarding copyright protections for AI-assisted works. The ruling reassures enterprises that their intellectual property will remain protected even as they integrate AI into their creative processes. This is particularly important in industries where brands and proprietary content are involved, such as advertising and media. Conclusion: the future of copyright in the AI era. The U.S. Copyright Office's report establishes a clear directive that while AI can assist in the creative process, human authorship remains essential for claiming copyright. This balance seeks to protect the rights of creators while acknowledging the evolving role of technology in artistic expression. As AI continues to advance and integrate into various creative fields, further discussions and potential legal clarifications will likely emerge. The ongoing evaluation of AI's impact on copyright will be crucial as courts, policymakers, and the creative community navigate the complexities of authorship and ownership in this new digital landscape. The forthcoming Part 3 of the report addressing the legal implications of AI training on copyrighted works will be a key development to watch in the coming years. In summary, the U.S. Copyright Office has reaffirmed the importance of human creativity in the copyright system, ensuring that while AI can enhance creative endeavors, it cannot replace the fundamental role of human authorship in securing intellectual property rights. The U.S. Copyright Office's recent ruling regarding the copyrightability of AI-generated content introduces several counterintuitive insights that challenge conventional understandings of authorship and creativity in the context of artificial intelligence. 1. Human involvement must be significant. One of the most striking aspects of the report is the assertion that AI-generated works can only be copyrighted if a human has made a substantial contribution to the creative process. This contradicts the initial expectation that AI being capable of producing sophisticated outputs independently might be eligible for copyright on its own. The notion that simply providing prompts or instructions to an AI serves as insufficient human involvement reveals a limitation in how we traditionally perceive the role of technology in creativity. 2. AI as a tool, not an author. The report emphasizes that AI functions primarily as a tool in the creative process rather than as a creator. This perspective is counterintuitive to the common narrative that AI systems, particularly generative models, are capable of autonomous creativity. By reinforcing that human authorship is central to copyright, the ruling essentially positions AI as an assistive technology which may downplay the advancements in AI's capabilities and the evolving nature of creativity itself. 3. No need for legislative changes. The Copyright Office's conclusion that existing copyright laws sufficiently address the challenges posed by AI-generated content stands in contrast to previous expectations that new legislation would be necessary to manage the complexities of AI in creative fields. This decision suggests a belief that traditional concepts of copyright, which have adapted to technological changes over time, can continue to apply without drastic revisions, an assertion that may seem optimistic given the rapid evolution of AI technologies. For public sentiment and reaction, the mixed reactions from creators and stakeholders also reflect a counterintuitive dynamic. While many creators expressed relief and optimism about the ruling as a victory for intellectual property rights, there remains a significant portion of the artistic community that is wary of AI's growing role in creativity. This duality illustrates an ongoing tension between embracing technological advancement and preserving traditional notions of authorship and artistic integrity. 5. Future implications for AI training. The anticipation of a forthcoming report that will address the legal implications of training AI on copyrighted materials introduces further complexity. The expectation that AI models are trained on vast amounts of copyrighted content without explicit permission raises questions about liability and fair use that are not easily reconciled with traditional copyright principles. This suggests a potential disconnect between how copyright law is applied and the operational realities of AI development. 6. AI in the creative economy. The report may inadvertently encourage a more integrated approach to AI in creative industries, where businesses and creators can leverage AI tools while still claiming copyright protection. This may lead to a broader acceptance of AI as a legitimate partner in the creative process despite concerns about the dilution of human authorship. The implications for the creative economy could be profound, as more creators might utilize AI without fear of losing their rights, potentially leading to innovative collaborations that redefine the landscape of artistic production. In summary, the U.S. Copyright Office's report establishes a framework that preserves human authorship while recognizing the utility of AI in the creative process. However, it also highlights a series of counterintuitive insights that challenge preconceived notions about authorship, the role of technology in creativity, and the future of copyright law in an increasingly AI-driven world. The U.S. Copyright Office's recent report on AI-generated content has established a significant precedent that merits close examination, particularly regarding the nuances that may be overlooked by the general public. Here are the key points of significance that could be easily missed along with their implications. 1. Definition of human involvement. The report emphasizes that for AI-generated content to qualify for copyright protection, there must be a significant human contribution. This goes beyond simply providing prompts or instructions to an AI system. The report outlines specific scenarios where human involvement is deemed sufficient, such as when a human author incorporates their own creative work into the AI output or significantly modifies the AI-generated material. The implications here are profound as they set a clear standard for what constitutes authorship in the digital age. This definition could influence how artists, writers, and creators approach the integration of AI into their work, encouraging a more hands-on creative role rather than a passive one. 2. AI as a creative tool, not a creator. The report reiterates that AI should be viewed as a tool in the creative process rather than a replacement for human creativity. This distinction is critical as it reinforces the idea that copyright law is fundamentally about protecting human creativity. The legal interpretation that AI-generated outputs lack copyright unless there is substantial human creativity involved serves to maintain the integrity of intellectual property rights. This understanding could shape future technological developments and the marketing of AI tools, as creators will likely seek to clarify their role in any AI-assisted project to ensure copyright eligibility. 3. No need for legislative changes. One of the more surprising conclusions of the report is the determination that existing copyright laws are sufficiently robust to address the challenges posed by AI-created works. Many in the industry anticipated a push for new legislation to account for the rise of AI technologies. The fact that no changes were recommended suggests a confidence in the adaptability of current laws and may indicate a reluctance to over-regulate an emerging technology that is still being understood. This could also foster a climate of innovation, allowing creators to experiment with AI without the looming fear of legal ramifications that new laws might bring. 4. Potential future implications. The report foreshadows the upcoming third part, which will explore the legal implications of training AI on copyrighted materials. This is particularly significant for companies involved in AI development as it raises questions about licensing liability and fair use. The outcome of this discussion could have wide-ranging consequences for the tech industry, especially for those leveraging vast amounts of data for training AI models. The anticipation of this report suggests that stakeholders should prepare for potential shifts in how AI tools are developed and used, particularly concerning copyright infringement claims. 5. Impact on various creative industries. The report's conclusions could have varying impacts across different creative sectors. For instance, musicians, visual artists, and writers may need to rethink their processes to ensure compliance with these new guidelines. This could lead to a renaissance of hybrid works where human creativity and AI-generated content coalesce in innovative ways. As creators adapt to these findings, we may witness new artistic movements that explore the boundaries of human-AI collaboration. 6. Reactions from the creative community. The response from creators and industry professionals has been overwhelmingly positive, with many recognizing the report as a victory for their rights. This sentiment is important as it reflects a growing acceptance of AI as a legitimate part of the creative ecosystem, provided that human authorship remains central. The shift in perspective may encourage more artists to embrace AI tools, seeing them as partners in creativity rather than competitors. This cultural change could lead to an increase in the production of unique works that blend traditional artistry with cutting-edge technology. In summary, the report from the U.S. Copyright Office is a landmark document that redefines the relationship between human creativity and AI-generated content. The emphasis on significant human involvement for copyright eligibility. The classification of AI as a tool, the decision against new legislation, and the anticipation of further discussions on AI training and copyright collectively shape a new landscape for intellectual property rights in the digital age. These nuances are not merely legalistic tidbits, they represent a fundamental shift in how creativity is defined, protected, and realized in an era increasingly dominated by artificial intelligence. The U.S. Copyright Office's recent report on AI-generated content has significant implications for copyright law and the creative industry. Here are 4 valuable points for in-depth analysis and discussion. 1. Human involvement as a criterion for copyright eligibility. The report underscores that AI-generated works can only be eligible for copyright protection when there is substantial human involvement in the creative process. This involvement can manifest in various ways, such as integrating human-authored content, creatively modifying outputs, or ensuring that human contributions are expressive. This point emphasizes the enduring principle that copyright protection is fundamentally linked to human creativity, which is crucial in defining the boundaries of authorship in the age of AI. The distinction made here challenges the notion that AI can autonomously create protectable works, thus preserving the human-centric foundation of copyright law. 2. AI as an assistive tool rather than a replacement. The report reaffirms the role of AI as a supportive tool in the creative process. It states that AI can aid in drafting, editing, and generating ideas, but the final authorship must remain with humans for the work to be copyrightable. This perspective aligns with historical adaptations of copyright law to new technologies, reinforcing the idea that while AI can enhance creativity, it cannot supplant the need for human creativity. This raises important questions about the future of creative industries and how they might evolve with AI's integration, as well as the implications for job roles traditionally held by human creators. 3. No immediate need for legislative changes. The Copyright Office concluded that existing copyright laws are sufficiently robust to handle the challenges presented by AI-generated content, indicating a level of confidence in the current legal framework. This stance contrasts sharply with previous calls for more protective measures for AI-generated works. The decision not to recommend legislative changes reflects a belief that the law can adapt to technological advancements without requiring a complete overhaul. This point invites discussion on the adequacy of current laws in addressing emerging technologies and the potential ramifications for future copyright disputes as AI continues to evolve. For future regulatory considerations, the report foreshadows ongoing discussions regarding the implications of training AI models on copyrighted materials, including licensing and liability issues. This upcoming focus is critical as it touches on the ethical and legal challenges of using existing creative works to train AI systems. The acknowledgement of these issues suggests that as AI technology advances, the legal landscape may need to adapt, leading to potential changes in how intellectual property rights are enforced in the digital age. This point can spur discussions about the balance between fostering innovation and protecting the rights of original creators in an increasingly AI-driven world. These points collectively highlight the delicate balance the U.S. Copyright Office is attempting to maintain between embracing technological innovation while upholding the core principles of copyright law centered on human creativity. Each of these aspects has profound implications for artists, legal experts, and policymakers navigating the evolving intersection of copyright and artificial intelligence. 1. Feist Publications Incorporated v. Rural Telephone Service Company 1991. This landmark case established that facts cannot be copyrighted, but the selection and arrangement of those facts can be. The U.S. Supreme Court ruled that a directory of telephone numbers created by Rural Telephone Service, which was simply a listing of public information, did not possess the originality required for copyright protection. This case is significant in the context of the U.S. Copyright Office's report on AI-generated content, as it emphasizes the necessity of human creativity and originality in copyright eligibility, paralleling the requirement for substantial human involvement in AI-generated works. 2. Burrow-Giles Lithographic Company v. Cerrone 1884. In this case, the U.S. Supreme Court upheld the copyright of a photograph taken by photographer Napoleon Cerrone of the playwright Oscar Wilde. The court ruled that the photograph was an original work of authorship, showcasing the creative choices made by the photographer in capturing the image. This case is often cited as establishing that photographs can be copyrighted because they involve a level of human creativity and judgment. It aligns with the recent findings of the Copyright Office, which stress that AI-generated content must also involve significant human input to qualify for copyright protection. 3. Oracle America Incorporated v. Google LLC 2021. This case revolved around the use of Java APIs in Google's Android operating system and whether such use constituted copyright infringement. The Supreme Court ruled in favor of Google, stating that its use of the Java API was fair use due to its transformative nature and the public benefit it created. This case illustrates the legal complexities surrounding technology and copyright. Similar to the ongoing discussions about AI and copyright law, the court's consideration of the purpose and character of the use reflects the Copyright Office's emphasis on human involvement and creativity in determining the copyrightability of AI-generated outputs. The U.S. Copyright Office's recent report on the copyrightability of AI-generated content represents a significant shift in how copyright law will adapt to the increasing integration of artificial intelligence in creative processes. With the establishment of new precedents, several future implications and trends can be anticipated. 1. Clarification of copyright eligibility. The core finding that AI-generated works can only be copyrighted when there is substantial human involvement will shape the landscape for creators and AI developers. This delineation will encourage quality contributions from human authors, ensuring that the creative process remains human-centric. As a result, we can expect a rise in collaborative projects where human creativity is blended with AI capabilities, leading to innovative works that maintain copyright protections. 2. Increased use of AI as a creative tool. The recognition of AI as an invaluable tool rather than a replacement for human creativity will likely result in broader adoption of AI technologies in various creative fields. Artists, writers, musicians, and filmmakers may increasingly integrate AI into their workflows to enhance productivity and creativity. This trend could lead to an explosion of hybrid works that utilize AI for initial drafts, concept generation, or refinement, thereby allowing creators to focus on the more expressive aspects of their art. 3. Potential for new business models. As copyright eligibility becomes clearer, new business models may emerge around AI-generated content. Companies could develop platforms that facilitate collaboration between human creators and AI tools, providing a marketplace for AI-assisted creations. Licensing agreements could evolve to include provisions for AI-generated contributions, allowing companies to monetize AI-assisted works while ensuring that human authors retain their copyright protections. 4. Legal and ethical discussions on AI training. The forthcoming third part of the Copyright Office report, which will address the legal implications of training AI on copyrighted works, is expected to spark substantial debate. Issues surrounding licensing, the ownership of training data, and liability for AI-generated outputs will need to be clarified. As litigation around these topics increases, companies may reconsider how they train their models, potentially leading to more ethical AI development practices that respect creators' rights. 5. Global impact on copyright law. The U.S. Copyright Office's decisions may influence copyright laws internationally as other countries grapple with similar challenges posed by AI in creative industries. Countries may look to the U.S. as a model for integrating AI into copyright frameworks, resulting in a more unified approach to copyright protection for AI-generated content across borders. This could foster international collaborations and standardize protections for creators who utilize AI tools. 6. Cultural shifts in creative industries. As AI tools become more prevalent in creative processes, there may be a cultural shift within creative industries. The acceptance of AI as a legitimate collaborator could lead to a re-evaluation of what constitutes authorship and creativity. This evolving perception may encourage a more inclusive definition of creativity that embraces technological advancements, potentially leading to new genres and art forms that blend human and AI contributions. 7. Ongoing monitoring and adaptation of copyright law. The Copyright Office's commitment to monitoring technological advancements suggests that copyright law will continue to evolve in response to new developments in AI. As AI becomes more sophisticated, the legal interpretations and applications of copyright will need to adapt accordingly. Stakeholders in the creative industries, including policymakers, legal experts, and creators, will need to stay engaged in discussions about how to best protect intellectual property rights in an increasingly AI-driven landscape. 8. Enhanced protection for creators. The clear delineation that human involvement is necessary for copyright eligibility may offer enhanced protection for creators against potential misuse of AI-generated outputs. This understanding could empower creators to confidently utilize AI tools knowing that their contributions are legally recognized, thereby encouraging innovation and creativity in the face of technological change. Conclusion. The U.S. Copyright Office's new precedent regarding AI-generated content marks a pivotal moment in the intersection of copyright law and artificial intelligence. As we move forward, the emphasis on human creativity will not only help preserve the integrity of artistic expression but also foster a collaborative environment where AI tools can enhance creativity without undermining the rights of human authors. The landscape of copyright law will undoubtedly continue to evolve, but with careful consideration and adaptation, it can support both innovation and the protection of intellectual property in the age of AI.